The case of Fraser versus Bethel was an important one for the clarification and solidification of how the First Amendment applies in school settings. The story starts in 1983 with Matthew N. Fraser, a then 17-year-old high school senior in Tacoma, Washington. His friend, Jeff, was running for school council, and Fraser wanted to perform a speech to show his support. Not just any speech, but something that would stick out to the audience. He decided to write a speech riddled with sexual innuendos, much to the dismay of his teachers, who warned him that he would be punished if he went through with it. He didn't care, though, because it would be funny. And, it was. The speech had such inspiring quotes as, quote, "I know a man who is firm. He's firm in his pants. He's firm in his shirt. His character is firm. But most of all, his belief in you, the students of Bethel, is firm." And, quote, "Jeff is a man who will go to the very end, even the climax, for each and every one of you." Needless to say, the school admin was very displeased, and they not only suspended Fraser for 3 days, but also banned Fraser, who was a top debate team member, from speaking at graduation. Jeff won the election, by the way. Anyway, despite this ban, Fraser got the second highest number of votes for graduation speaker from the other students, but the school still banned him from speaking. Fraser found all of this to be very unfair, and he, with his father, decided to sue the school for violating his First Amendment right to free speech. His case first went to the district court, and the judge agreed with Fraser and ruled that the school violated his First Amendment right, and the punishments they gave him were not valid. Fraser also got almost $300 as a settlement. The school district was not done, however, and they appealed the decision and took the case to the Ninth Circuit Court of Appeals, arguing that they punished him fairly because he disrupted the educational process. Luckily for Fraser, the appeal court agreed with the original decision that the school violated his rights, partially because the school did not have good enough evidence that Fraser's speech actually disrupted any classes. The court argued that previous cases relating to free speech in schools, like Tinker versus Des Moines, established that in situations that are not directly academic, like in this case, a student-run assembly that was not mandatory to attend, the students are fully justified in using their freedom of speech, as long as it is not directly interrupting the educational process. One of the judges, Eugene A. Wright, dissented, however, saying that, quote, "The court holds today that school authorities are powerless to discipline a student who makes a crude and sexually suggestive speech during a school assembly, and, quote, the assembly and the student elections associated with it were part of the official school curriculum, designed to teach rhetoric and leadership," unquote. Therefore, the speech was subject to the school's discretion if it was appropriate or not. Eventually, in 1986, the case was brought before the Supreme Court. The judges ruled 7-2 in favor of the school district, arguing that students do have freedom of expression in schools, but it's more limited than an adult's freedom of speech, especially when it comes to vulgar or offensive speech, in order to better protect students from inappropriate language. They also came to the conclusion that the punishments Fraser received were justified because the school is not subject to the same rules about discipline as a court. A school doesn't dole out jail time or anything, so they're allowed to have more vague rules. The overall opinion of the court was that Fraser was too indecent in his speech, but that ultimately it's up to the school's discretion. Quote, "Surely it is a highly appropriate function of public school education to prohibit the use of vulgar and offensive terms in public discourse. Nothing in the Constitution prohibits the states from insisting that certain modes of expression are inappropriate and subject to sanctions. The determination of what manner of speech in the classroom or in school assembly is inappropriate properly rests with the school board," unquote. Even though most of the justices agreed, it's interesting to hear their opinions on Fraser's speech. Justice Brennan, who concurred with this ruling, wrote, quote, "The court, referring to these remarks as obscene, vulgar, lewd, and offensively lewd, concludes that school officials properly punished respondent." By the way, when they say respondent, they're referring to Fraser. Quote, "For uttering this speech, having read the full text of respondent's remarks, I find it difficult to believe that it is the same speech the court describes. To my mind, the most that can be said about respondent's speech is that respondent's remarks exceeded permissible limits. Thus, while I concur in the court's judgment, I write separately to express my understanding of the breadth of the court's holding." Basically, he didn't think it was that big of a deal, and I agree, honestly. I think it's just kind of funny. Justice Brennan also added, quote, "The court speculates that the speech was insulting to female students and seriously damaging to 14-year-olds, so that school officials could legitimately suppress such expression in order to protect those groups. Indeed, to my mind, respondent's speech was no more obscene, lewd, or sexually explicit than the bulk of programs currently appearing on primetime television or in the local cinema." Another justice, however, Justice Marshall, dissented, saying, quote, "In my view, the school district failed to demonstrate that respondent's remarks were indeed disruptive," unquote. Justice Stevens also dissented, arguing, quote, "This respondent was an outstanding young man with a fine academic record. The fact that he was chosen by the student body to speak at the school's commencement exercises demonstrates that he was respected by his peers. This fact indicates that he was probably in a better position to determine whether an audience composed of 600 of his contemporaries would be offended by the use of a sexual metaphor than is a group of judges who are at least 2 generations and 3,000 miles away from the scene of the crime. All in all, I think this case is an interesting one, not to mention entertaining, and it was necessary to better flesh out how free speech actually applies in schools.